Assalamualaikum warahmatullahi wabarakatuh and a very good morning everyone. Welcome to this webinar Humanizing Innovation at MMU webinar series organized by the Industrial Collaborations and Engagement Center ICEC together with Research Industrial Collaboration Engagement Division MMU and in collaboration with the Center for Sharia Law. Um, Let me just, on behalf of the organizer, to thank all of you for being here today, for spending your time to be with us, to listen to our esteemed speakers for the topic of access to justice in Sharia court experience during pandemic. Ladies and gentlemen, I am Muhammad Nur bin Abdul Rahim, your moderator for today's webinar. I am the lecturer at the Faculty of Law, Multimedia University, and also the chairperson for the Center for Sharia Law, Multimedia University. A bit introduction for our center. We are a research center established under the Faculty of Law, Multimedia University, which aim to nurture, to harness, to foster research in area of Sharia and law through research activities, seminars, consultancy and advisory work, collaborations, and publication. Ladies and gentlemen, today's webinar is aimed to first enlighten the understanding of justice from the Sharia perspective, to share the experience of Sharia fraternity in coping with the pandemic, and also to synergize the academy and the industry in improving Sharia court practices. With us this morning, we are very honored to have two esteemed speakers, one from our own MMU, from our Faculty of Law, Multimedia University, and another one is a esteemed speaker, okay, from our industry, from the Sharia fraternity, where I would like now to introduce our speakers. Firstly, from the industry will be the first speaker, okay, Datuk Zainul Rijal bin Abu Bakar. Okay. Dato Zainul Rijal is a big name in the industry. Okay. He's an advocate and solicitor. He's a Sharia counsel. He's also a mediator, arbitrator, and commissioner for oath. He obtained his education, his statutory education in LLB from IIUM. He obtained his LLM from UKM. He also was a holder of the diploma, the postgraduate diploma in law and Sharia advocacy, UITM, as well as an advanced certificate of mediation from a court group, Australia. He had been awarded with the title of Dato from Perak in 2011, and he's also the honorary superintendent of PDRM since 2012. And he was also part of our university as an adjunct professor in 2012, and he is a big figure. He contributed a lot to society, where he is currently the president for the Malaysia Muslim Lawyers Society Association, or Persatuan Peguam Muslim Malaysia. He is also the panel member and expert for the Sharia Community Attorney General Chamber Malaysia. He is the head coach of mediation for the Court Group Australia, and also he is the member for Jawatan Kuasa Kaedah Mahkamah Syariah, Jabatan Kehakiman Syariah Negeri Selangor and Wilayah Persekutuan. If you list down all the list of contribution and participation that he has, I think we need to have another session for that. So thank you. Let us welcome Datuk Zainul Rijal to our program this morning. And next, I would like to introduce our next speaker from our own Faculty of Law, Multimedia University, Professor Dr. Abdul Muhaimin bin Nordin Ayus. Okay. Professor Dr. Abdul Muhaimin bin Nordin Ayus has served in the Faculty of Law, Multimedia University, and he is also have been serving in University Islam Sultan Sharif Ali Brunei, and also Ahmad Ibrahim Kuliah of Laws, IIUM. He obtained his education mainly from IIUM, where he obtained his degree in LLB, his master in MCL, and his postgraduate in Diploma in Sharia Legal Practice from IIUM, and he obtained his PhD in law from the Aberdeen University. He has a very vast experience serving various institutions. Among others, he was also part of our adjunct professor before joining us as an academician here. And he was also the former dean for the Faculty of Sharia and Law, University Islam Sultan Sharif Ali UNISA from 2010 until 2015. He also was the ADB consultant and the faculty advisor for the Asian Development Bank and Maldives College of Higher Education, Republic of Maldives, who is responsible to set up the faculty of law there in the University of Maldives, the National University of Maldives from 2000 until 2003. And he was also the former dean of the Ahmad Ibrahim College of Laws, ICOL, in year 1999 until 2000. He's a big name in the law of contract, legal system in Brunei ASEAN, and in law of tort, contemporary Islamic criminal law, in Sharia penal code, in evidence law, in Sharia court, and he had written and presented at least 18 international and national conference seminar papers on building contract laws, Islamic criminal law, law and Sharia curriculum design and implementation of hudud and qisas law. So we welcome Professor Dr. Abdul Mohamed to our webinar this morning as well. Thank you for both our speakers. Ladies and gentlemen, without further ado, let us continue, or let us begin our event this morning by first inviting our first speaker, Datuk Zainul Rijal bin Abu Bakar. Datuk, okay, for the first question that we want to share this morning, from the practitioner, from the industry player, could you share your experience on how Sharia Court provide access to justice, and what would be the face or the challenges that you have, especially during this pandemic time? Dr. Zainul, the floor is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and good morning to everybody. Thank you to Encik Muhammad Noor, moderator for this morning. My co-presenter, who was and still is my teacher, Professor Dr. Abdul Mohamed Nordinayus. And I thank MMU, especially the Faculty of Law and the Industrial Collaboration and Engagement Center, ICEC, for inviting me today. It has been quite some time I have not come to MMU after the expiry of my adjunct professor tenure in, I think, 2014. But I'm today, I would consider I'm stepping my foot in MMU via technology today. I thank everybody for inviting me. Before I answer the question from the moderator on the accessibility of justice in the Sharia Court, I would like to, in passing, I think Prof will cover a bit more details on this. I would like to bring the premise of the Sharia law into the proper perspective before we can discuss further on the accessibility of the justice in the Sharia Court. Yeah? How do Sharia Court provide access for justice? It is quite a fallacy if we compare the justice system in the civil court and the justice system in the Sharia Court. Because if we want to compare something, we have to compare apple to apple. We cannot compare apple to an orange because it will be different criteria involved. It is also, if we are looking at the Sharia law, we have to use the Sharia law spectacles. We cannot use the civil law spectacles to see the Sharia law. So there are a lot of, quite a number of differences between the Sharia law and the civil law, and as well as Sharia court and the civil court. Yeah? The glaring difference are on the source of law. Justice in the Sharia court, in the eyes, are justices in the eyes of Allah and His Prophet, where Islamic law provide definitive and speculative rulings. Yeah? Definitive rulings means it's a fixed ruling, fixed law, which cannot be changed or interpreted otherwise, except in a very rare circumstances. such as masalih musalah, that are a lot. There are something that needs for us need to interpret otherwise, but it is in very rare occasion. The speculative ruling are rulings or laws that can be interpreted. It is the ijtihad. It vary from circumstance to circumstances. It vary from maybe one state to another state, one school of law and another. It is allowed and permissible under the Islamic law. For example, the mechanism of divorce. Under the Shafi'i school of law, only two circumstances where the Muslim are allowed to have a fasakh. However, in the Hanafi and Maliki school of law, there are a lot more reasons to apply for the fasakh. So we have to bear in mind in the Islamic law, there are definitive rulings. There are also speculative ruling. But it is not as what we perceive in the civil law. Whatever in the law, then we can interpret according to literal rules, golden rules, mischief rules, and a lot of other kind of interpretation. This is what we have to bear in mind in order to look at the Sharia law with the spectacles of the Sharia law and not with the civil law. On the second point, a lot of people, I believe that they blame the Sharia court. They compare civil court and the Sharia court on certain decision made by the Sharia court. But we have to know exactly what are the Sharia courts. Quite a number of people who accuse the Sharia court with a lot of accusation, but they themselves have not even stepped foot in the Sharia court. What more to argue before the judges? I start with a statement that Sharia court are not as independent as the civil courts. They are a creature of the statutes, and the officers are still the penjawat awam, public officer, who have to obey a lot of regulations imposed by their respective states. There are states governed by the states. If their respective states disallow certain innovation, they are bound to follow. When we look at the civil court, we know the judges of the civil court, the higher court, high court, court of appeal, and federal court, their mechanism of appointment are stated in the federal constitution. They have a judicial committee who choose which judges to be appointed or elevated. But in the Sharia court, they are still public officers. They are bound to follow the rules and regulation by as penjawat awam. Their jurisdiction are limited, and some portray that Sharia courts are ineffective, delay in hearing cases, and unfair. However, when we propagate the increment of jurisdiction of the Sharia court, such as the Act 355, amendment of certain laws giving procedural rights to the Sharia court to hear judicial review application, for example, a number of people objected to it. So on one hand, we want Sharia court to develop, but on the other hand, the law, the mechanism, the system did not allow the Sharia court to develop, to be more independent, to do innovative decision. They are crippled with a lot of rules and regulation and directions. Okay, during the pandemic, I can share with you a few scenarios. How do the Sharia court react during the pandemic? My own cases, for example, on the eve of the lockdown, full lockdown, a father of 3 young kids took his children from his ex-wife and refused to return the children to his ex-wife, although she has obtained a custody order from the Sharia courts. By the time she learned that the ex-husband refused to return the children, the Sharia court is already closed. It's a 4:45 already. And the next 2 weeks, they have declared the court registration are closed. The announcement were made that the Sharia court will not accept any registration and the counters are closed. So what would happen to this mother, this mother and other mothers who face similar predicaments? The children was brought by the ex-husband, and the ex-husband refused to return the children. And the Sharia court says that all registration cannot be done during the pandemic. So there no certificate of urgency, no nothing can be, even the counter are closed. I have communicated with the Sharia court. They say that they have to follow the instructions from the state secretary, that they will not allow to open the counter. So how do this mother will access justice during this pandemic? The second scenario, in one evening, a Sharia court has granted a committal order against an ex-husband who was said to have refused to provide documents of his companies in a discovery proceeding. An injunction were entered against him to certain extent operate his company. He sought advice from me, a Sharia lawyer, but by the time that he met us, full lockdown was imposed by the Sharia court. So for 2 or 3 weeks, this ex-husband, a businessman, cannot operate his company because of the injunction obtained by his ex-wife. In particular, the company that he has is selling used car. So one of the order in the injunction is that the company cannot dispose the assets of the company. All those the assets are the used car that they are in the business of selling of the used car. So during this 1 month, the company suffer. There's no income for the company. So how would we say that justice is served during this pandemic, where we cannot even file an application to remove the injunction in the Sharia court? So this is a clear example where justice are denied to the parties from accessing the justice in the Sharia court. However, as I said, if we were to blame the Sharia court 100%, I think we would be wrong, because they have to follow the instructions from the state secretary. The state secretary gave instructions to all the penjawat awam, all the public officers, regardless whether they are Sharia court or not. This is the reason why we are asking the Sharia court to be more independent. They don't have to be under the purview of the penjawat awam. They can decide themselves which are what are the cases that can be heard in urgency via certificate of urgency. We can be which can be delay. What are cases that can be set aside? It doesn't matter to have more time for the cases to be decided later. Now, during this pandemic, but we also have actually under the Sharia court, we have online hearing on application by both parties. The reality in practice, if both parties, the plaintiff and the defendant, the applicant and the respondent, agree for online hearing or trial, then the judge may allow for online hearing. But this only applicable when both parties are agreeable. This comes to another question. some lawyers, I have to say honestly, try to delay the matter for the benefit of for the client. They do not, they for any reason whatsoever, they don't agree for the online hearing because they want to delay the hearing of the cases. So if the court, the Sharia court, would only hear the matter on consensus via online, then it may be difficult for some urgent matter to be decided instantly by the court, because the court needs consensus from both parties. Uh, on perusing the act, the procedure, I think there are procedure that the court can invoke in order to depart from the Akta Tata Cara Mal Mahkamah Syariah. For example, if you look at section 2 of the Sharia Civil Procedure Act 1998, I'm reading from the Federal Territories one. Section 2 says that this act shall have effect in all proceedings commenced in Sharia court, except as otherwise provided under any written law or ordered by the court. The phrase ordered by the court is very important. If the court order that certain provision of that Atta Tata Cara Mal will not be applicable in a particular hearing, for example, to enable the online hearing, I think I'm of the view that the Sharia court doesn't even need consensus from both parties to agree on online hearing. Therefore, it will encourage party to settle to prepare for the cases earlier via online hearing. Most of the cases, applications, appeal, we don't have to examine the witnesses of that. It is via submission only. So I think section 2 is applicable. The judges can invoke section 2 of the Akta Tata Cara Mal, so that online hearing can be in place in the Sharia court. Another section that we can go through is that section 120 of the same act on appearance. 1201 says that any party may appear in person or through his peguam syar'i, but every party shall be present at court at the hearing except as otherwise allowed by the court. So under section 120, the court can allow parties to attend the hearing via technology. There's no physical attendance is required, but the court has to make an order via section 120 on appearance. So there are rooms that can be applied in order for the Sharia court to enable the Sharia court to conduct hearing via the technology and dispense with the physical attendance of the parties. This is very important during this pandemic because, of course, we all know if a lot of people come to the same vicinity to the court, then we are afraid that the COVID-19 cases will be increased. So attendance via technology, via Zoom meeting, via Google Meet can be done by applying section 2 and section 120 of the Akta Tata Cara Mal Mahkamah Syariah. We don't need, the judges don't need actually the consent from both parties to get the to agree on the online hearing. On the other part that I would like to point out is that during this pandemic, most of the Sharia court has imposed, if you want to file a case in the Sharia court, you have to have an appointment to the court. This is to cater how many person come to the court at what time, so that it will not be crowded at the counter of the Sharia court. This is a good practice, but when I check in for the peak time, when I apply for the appointment to the registrar, if I apply today, I may get the date in November or December. So it will be 2 or 3 months ahead, away from today. So what would happen to during these 2, 3 months? Uh, but we have discussed with the registrars of the Sharia court, especially in Kuala Lumpur and in Selangor. If the peak time is as such, we have to get a date. The date may be in 1 or 2 months' time, but in cases of urgency, we have to email the registrar, and the registrar will look into our email and see whether it is really urgent or not. If it is urgent, then they will give an earlier date. If there's a deadline, for example, we have to file notice of appeal within 14 days, and the date is only a few days ahead of the time, then we have to email the registrar. We cannot just walk in to file the document, but we have to email the registrar. The registrar will fix a date for the filing. So these are some of the innovation that has been done by the Mahkamah Syariah in order to dispense with justice during this pandemic. There are a lot of presumptions even before the pandemic against the Sharia court. For example, the Sharia court used to have all male judges, but now there are female judges. There are judges at the lower court, the high court, female judges at the high court, and there is, I think, still is a female judge in the Court of Appeal, especially in particular in the state of Terengganu, Datuk Paduka Zaliha Kamarudin, Court of Appeal judge. I think she's the only female Court of Appeal judge in Terengganu. But although there are female judges in the Sharia court, most of my clients, female clients, actually, this is we have to see whether we are whether it will serve the purpose or not. Most of my female client actually doesn't want a female judge to adjudicate their matter, because the female judges are very strict. And there's a lot of lack of knowledge on the part of the parties. Improvement of knowledge also has to be made among the judges, especially in the worldly matters, such as the ownership of the asset, types of asset, modern technology, land law, companies law, etc., etc. Judges should apply. And I think my time is already finished. I just take 1 or 2 minutes. I think one important aspect that I want to raise is that I think the Sharia court judges should apply more inquisitorial approach in conducting trials instead of adversarial, because quite a number of cases where the parties are not represented by the lawyers, so the parties are not able to convey certain issues to the judge, and the judge kept saying that I'm bound by adversarial system, I cannot ask a lot of questions. I think they should have more inquisitorial nature approach in the Sharia court to serve justice to both parties. I think I will end now. If there's any question after this, I think I will be glad to answer after this. Thank you very much.
Thank you very much. Thank you very much, Dr. Zanuja, for your insightful view on what is happening there in Sharia Court. I think to have this insider information or story is very important for us to understand what is the challenges that is faced by the industry player. Thank you again, Dr. Zaino, for your
Welcome.
sharing just now. So, ladies and gentlemen, we will continue with our second speaker. But before we do that, I would like to request, or rather to promote to you, that if you have any question that you wish to post to any of our members, speakers, so you may leave your comment or your question in the chat box in the Facebook live. So we will pick up your question there, and we will accordingly uh, pose the question to our esteemed speakers today. So, ladies and gentlemen, let us move to our next speaker, i.e., Professor Dr. Abdul Muhammad Bainuddin Ayus. Prof, would you kind to share with us your opinion on today's topic, perhaps on the part of the fundamental of justice and how the access of justice in Islam should be? Prof, over to you.
Right, thank you very much, Brother Mano Ibrahim. Assalamualaikum warahmatullahi wabarakatuh. Auzubillahi minasyaitonirrajim. Inna Allah ya'murukum an tu'addul amanati ila ahliha. Wa idza hakamtum bainan nasi an tahkumu bil 'adl. Inna Allah ni'amma ya'izukum bih. Inna Allah kana sami'an basira. First of all, I would like to express my gratitude to the Research, Industrial Collaboration and Engagement, RICE MMU, the Industrial Collaboration and Engagement Center, ICEC, and the Center for Sharia Law, Faculty of Law, MMU, for giving me this opportunity to share some views and opinions. Most of it probably would be off the cuff, not really going too much technicality on it. And then, and not forgetting, I'm also grateful to the MMU personnel behind the scene in the MMU studio for giving this presentation a boost on the topic. So I started with the recitation of this ayah from Surah AlNisa, verse 58. There are two things which are of great importance in that ayah. That is, the first thing is the amanat, amanah. And secondly is the justice. Specifically, this ayat is related, the revelation of this ayat is related to certain trust of keeping the key to the Kaabah. Yeah? But I'm not going to deal with the subject on that. But the Mufassir, like Ibn Kathir, in his tafsir, he mentioned that this ayah could be applied generally, right, in general term. So when we talk about justice, it is simply fairness in the way people are dealt with. That is the dictionary meaning that you can get, okay, from Cambridge Dictionary and all. Yeah? Or it could be fairness, moral rightness, a scheme of system of law, and every person where he would receive his due from the system, right? And both under the natural and the legal law, legal for perspective. Okay? So when we look from the Islamic perspective, from the ayat, a few ayats in the Quran, we can see that the Creator, Allah Subhanahu wa Taala, commands us to the mankind to behave in a fair and just manner. Okay? It is for all, not only for justice and the court and the judge. Okay? Right? It is for all, right? Where mankind to behave in a fair and just manner. And then for us to protect the right of others. Between us and others, it is our duty to protect the rights of others. And then to be fair and just with people. Right? Fair and just with people. And then to side with the one who is under oppression. Right? Now we mostly forget about those who are oppressed. Right? as long as we are not oppressed, we don't care. Right? That's the problem, the attitude that we have. But actually, we are commanded to side with the one who is oppressed, and then to help and be fair with the needy and orphans. Especially, we have seen what's happening during this pandemic. We can see a lot of philanthropists, with a lot of kind-hearted people sharing what they have with the have-nots. Yeah, we are very proud of that. We can see that that part of justice is working. Okay, and then to be just and not go beyond the boundaries set by Allah, even with our enemies. Even with our enemies, we have also our duty, our obligation, yeah, to treat them with justice, okay? To be just with them. So here we can see that we are required to be fair and just in all circumstances, in all situations, right? We must establish justice in society. Now, going back to the word amana, amana is trustworthiness, the trust that is put upon us in whatever profession that we have, right? The judges, they are entrusted with uh, dispensing justice, but on his own side, within himself, he must be always be prepared to learn and relearn. Uh, Otherwise, justice may not be dispensed with properly in line with what is happening today. That if they just simply look into the fiqh book alone, they may not go far. I've seen a lot of judgments in Pakistan Sharia court, even in our local Sharia court dealing with criminal law, for instance. There's a lot of things which are not properly put forward in the cases, right? And we have seen also some courts have already put up the guideline, but since our Sharia court in Malaysia, for instance, they are not under one administrative roof. It is by constitutional constraint. Each Sharia court is based in the state. If the case, if the guidance which is very well placed by the court in Malacca, for instance, will not be put uh, into great importance by other Sharia courts. Oh, this is Malacca decision. Even though the guidance is good, the guidance provided by the Court of Appeal, that should be followed, but should be considered, not to be followed, but at least considered. But some other Sharia court ignored it, right? So these are the things happening where it would deprive those who come to justice may not get the proper justice because the amanah was not carried out by those who are administering justice. Right? So as I said, there's a lot of things, even us like lecturers, right? A lot of things need to be learned and relearned. Okay. Sometimes, if we go to Sharia court, for instance, if we have only fiqh in mind, the fiqh book only, sometimes we get confused. Okay. We need to look beyond, beyond it. So, for instance, we have a very popular case. I don't like to mention the case, but people will know, right? This happened in Pahang, where a lady was charged for drinking liquor. She was having tiger beer, right? I think she pleaded guilty and convicted and was fined the maximum fine of 5,000, okay, and 6 stroke of rotan. And it became a national and international issue. And finally, His Highness, Royal Highness the Sultan intervened and substituted the caning to community service, right? So how to see justice being administered to this type of cases, right? I discovered one flaw in the law, right? Under section 136, if I'm not mistaken, of the Pahang enactment, upon which the charge was based, was it 136, Dato'? I'm not that really having good memory of the section, right? It says that if you are convicted for drinking liquor, you are liable to be fined up to 5,000 ringgit, or jail, imprisonment for up to 3 years, and 6 rotan. The word and 6 rotan there is ultravirus Acta or Act 355. Yeah? 355 provides the jurisdiction for Syariah court, yeah, of fine up to 5,000 or imprisonment up to 3 years or 6 stroke of rotan. Yeah. Whatever amendment being proposed or this while, I don't have any problem with that, okay? But we want to see justice done, right? So if the law is faulty, right, something must be done, right, to serve justice to all, even to the victim, or even to the accused person, you see. Right? If the hands of the judges there, the judge there was not tied with an rotan, perhaps he not impose the rotan, okay? Because under 355, it is all, not and. Okay. So if I were the lawyer, perhaps I will go on that constitutional issue, right, to serve justice to everyone, right? So on other aspects, when I studied all the laws, then it was in the case happened in 2008 or 2009, right? I was looking into the case then. I found that another state also have the same provision, that is Kelantan. So I had the opportunity of bumping into the Menteri Besar of Pahang, whom I know quite well when I was in UAE. I raised this issue to him. Perhaps the State Legislative Assembly, I said, should be holding to the trust given by the law, by the Constitution. If the 355 says 5,000 or imprisonment or rotan, stick to it. Don't create something which may render the law ultra-virus. It can be challenged, right? So, I mean, justice must be done to everybody, right? Not only the courts to mete out justice, but even the State Legislative Assembly must also put up the law properly. Otherwise, I think justice may not properly be seen, right? And another situation, for instance, yeah, going to hudud law, the case in Pakistan, the case of Uloom Ali, for instance, quite a famous case, where a man was arrested in the mosque for trying or attempting to steal a clock from the wall. There are two versions of the stories. One version said he was caught, his leg was grabbed by one of the witness, the person who arrested him, while he was standing on the pulpit, atas mimbar, on the pulpit. He was trying to detach the clock from the wall. Right? Another witness said, we caught him when he came down from the pulpit with the clock. Right? Okay. So here, when we have trial on hudud cases, right, first and foremost, either for conviction on the hudud charge or conviction on the ta'zir charges, right? Ta'zir is the disciplinary punishment allowed by the ruler or by the country. Okay? Hudud is from the scriptures, from the Quran and Sunnah. Okay? So either to convict a case, either under hudud or ta'zir, you need to satisfy the rukun, the essential of the offense. If it is sariqah, theft, right? If you look into many definition of sariqah or theft in all the modern statutes that we have, yeah? From Pakistan to Nigeria to Malaysia to Kelantan and Terengganu, they have the hudud law, but we cannot enforce. Right? And then we go to Brunei, right? They went in line with the one in the kitab written by Abdul Qadir Auda, where 4 essentials must be proved before the person can be convicted either to hudud or to ta'zir. Right? There are certain opinions to say that, to convict under ta'zir, no need to follow so much. To me, that's wrong. You breach the trust under the law, see? The trust under the hukum. See? In everything we do in Islam, there must be the rukun, even in prayers. You know the rukun, yeah? Rukun qawli, I think 5, some said 3, some said 5, right? Something that you must utter. Without that, the whole prayer will be gone, you see? So even though in hudud, yeah, you need to prove the existence of the rukun, the 4 one. Yeah? First, the taking, the what I call the removing of the property must be done surreptitiously, yeah? In secret, not to the view or to the knowledge of the owner of the property. That's very important. Okay? Secondly, the property must be movable property. Right? And then thirdly, the owner of the property never give any consent for the removal. Right? And fourthly, the niyat, the intention to remove. Right? So that must be proved. Whether the case would fall under hudud for punishment or ta'zir for punishment, then you see whether the conditions attached to all these rukun and independent conditions, I think all of them, I think more than 16 conditions, right? Before you can put under hudud, right? Then only you decide. If certain conditions are not satisfied, conviction can be done, but the offense would be punished under ta'zir, the discretionary punishment. Right? For instance, if the age of the accused is below the age, the capacity determined by Sharia. In some countries, they put as 15 qamariyah years. In some countries, 18 qamariyah years, depending on the choice of the state. Okay, in Brunei, they choose 15, very young. Right? In Pakistan and all, they choose 18. In Kelantan, Terengganu, I think they choose 18. Right? Because our Muslim community in Malaysia are from various school of thoughts, school of fiqh. Yeah? We have the Hanafi, we have the Shafi'i, we have the Maliki, we have the Amali and all. So we have tried to be more rational in that sense. Okay, so these are sometimes confused in the prosecution of cases, right? Especially in the early times in Pakistan. So although the person was charged for stealing the clock, yeah, even the rukun, the 4 rukuns were not satisfied. The syarat, the condition for the removal of the property, yeah, the rukun is removable, but the syarat attached to it is that the property must leave the hirs. The hirs means the place of custody. Where was he arrested? Is it outside the mosque or inside the mosque? He was arrested inside the mosque. Even that thing, that's why I said we have to learn and relearn. Right? Don't simply catch someone who is stealing and then put under hudud for sensational or for euphoric purposes. People are very euphoric, very emotional when it comes to hudud. People want to see the hand is chopped off. People want to see stoning to death. Yeah? People want to see somebody lashed in the public. Forget it. Yeah? Forget it. Learn more into it. A person's dignity must be protected unless it is a adultery case where you can, the Quran says you can punish in public. Yeah? Some other hudud you don't have to. See? So we have to be very careful to serve justice here. Justice here is all encompassing. Don't only look at justice when the court punish the person. Okay, look at the overall justice. Are we discharging justice on the innocence of the accused or on the accused whether he's guilty or not? Don't simply catch him. Oh, you are convicted for hudud punishment. This is not easy. Okay, not easy. Once we do injustice, I think what the Prophet has said, Prophet ﷺ said, to put it in a mild words, perhaps one judge will go to paradise, the other 2 will go to somewhere else. Yeah. It's not easy. Yeah, amanah is not easy to carry. Even though if you are a judge, even though you are, sorry, Datuk, you are program syar'i, or even like me, teaching the subject sometimes, even anybody, right? We have to learn and relearn. Not to say that, oh, we have the obligation to introduce or enforce hudud. Yes, we have the obligation, right? But when we have hudud, what should we do? And our personnel have to learn and relearn a lot. Right? I had commented one case, right? Don't mention any country because they may be mad at me. Right? One boy was arrested for sarikah. They cannot put under hudud because there was no the requirement of eyewitness was not there. Adil eyewitness was not there because this boy was with a friend having coffee at a restaurant, right? So when the friend wanted to excuse himself to go to the loo, he gave his bag to this accused person, the boy. Can you take care of my bag, right? So the guy went to the toilet, and while the friend was in the toilet, he peeped through inside the bag and picked up 100, 100 and put in his pocket. It was recorded on CCTV. When they went home, the complainant discovered that he lost 100. He went to report to the police. The police went to the restaurant, checked the CCTV. It was his friend who took the 100 note from the bag and put it in his pocket. And he was charged for sarikah. Not sarikah to be punished with hudud, with had, but sarikah to be punished with discretionary or ta'zir, which is much more heavier than the sentence in the penal code. He can be punished, I think, up to 10 years or 7 years, but in the penal code, I think our penal code 7 years, but in that country, 3 years. Right? So, the first thing I said earlier, did they put proper consideration on the rukun, on the essential of sarikah, the 4 things that I mentioned? It must be the thing is given to you without consent or taken without consent. In this case, the victim consented that his bag to be looked after by the accused person. How come it becomes sarikah? And unfortunately, he was punished with 5 months imprisonment. 18-year-old, 5 months imprisonment. Until he died, he will not get any job with the government or private sector. Is that what Sharia wants? Even Sharia allows, since this hudud mostly come under the right of God, haqqullah, huququllah, most of the offenses, including theft, according to one kitab, one fiqh book written by, I cannot remember, by Dr. Khin something. He said, if the owner were to pardon the victim, right, there's no need to take him to court. If the matter is taken to court, the judge has no other option but to carry out justice according to law, right? But this thing can be compromised before you go to court. That mechanism is not there in our system. Right? That mechanism is not there. Giving the chance to come back to normal life as required by the Sharia, by religion. Right? People should be given chances, especially 18 years old. Right? If it is civil court, they go under the juvenile court, for instance, right? Most probably, right? But when it comes under Sharia law, they have to go because he was above 18, above 17. Above 15, right? Qamariyah. 15 Qamariyah years is only 14 years, 8 months or 7 months. To me, it's too young. Too young. So when we look at, that's why I say amanah is there. When this is amanah, the person who is in charge of prosecution has the amanah to know when to charge and when not to charge. Don't simply, for the sake of KPI, whatever, you simply take people to court. When you go to court, you cannot do anything else. You cannot do anything else. The court will have to carry out their duty, their amanah also, right? So, access to justice is to me is in a wide spectrum, right? From every angle, right? For I call that for civil cases, for mal cases, I agree with what the Dato' said. No, there's no problem with it. But when it comes to hudud cases, I don't think online trial is should be allowed. Right? because of the need of very strict proof, evidence. It must be given face to face, so that the one who brought the evidence could be challenged by the defense, and even the required witness, right? Adil witness, 2 for theft at least, or 4 for adultery at least, must be examined and cross-examined, and even his integrity has to be checked through the tazkiyatul shuhud procedure. For every witness, you need 2 persons to testify that he is an upright person. It's very lengthy process. It has to be done face to face, right? I think that is what justice wants for the so that the evidence produced for hudud cases must be beyond all doubts. It must be yakin, not beyond reasonable doubt, which is apa tu? Apa dah tu? Beyond reasonable doubt in Islamic law.
Melampaui ikrar munasabah. Melampaui ikrar munasabah.
Ikrar munasabah. In Arabic term, in Syariah term, yakin is the top one.
Ghalibul zan.
Zan, yeah. Zanul gharib, zan and zanul ghazib. So all these things is similar to the civil court. So there's not no problem with that. Okay. So when I look at all this problem, I go behind it. Okay. What actually is really required by Islam? Just take the case, for instance, right? When Sayyidina Omar bumped into a person who was drunk in his house. Okay. Sayyidina Omar was his friend. He liked to patrol every night to take care of his subjects, to take care of the citizen. He came by a house. He heard somebody was having a merry time, right? So he peeped through a hole or somewhere in between the wall, and then he pushed the door and went in. In another story, another narration, the writer said he jumped through the between the wall and the roof. There's some opening, so he jumped in. Right? He went into the house and told the drunken man, "You can be flogged, can be rotan for drinking." The man replied, "I committed one offense, drinking. But you, rightful Caliph, Amirul Mu'minin, you committed 3 maksiat." And then he told Sayyidina Umar, "I am a Muslim. Right? When you want to come to my house, did you give salam?" To Sayyidina Umar, salam is important. Right? He had to, what to say, surrender lah. Second, how do you know that I was drunk? Did you peep? It is against the Quranic ayah, wala tajassasu. Don't start looking after people's fault and sins. And thirdly, I'm a Muslim. This is a Muslim house. Did you ask for my permission to come in? Did Sayyidina Umar give him a punch? Or did he beat the drunken man? Right? Or did him drag out to the court or to his counsel, to this his counsel? No, see? He realized that he also made a mistake. He gave the person a chance to repent. That is what Islam wants. Any wrongdoer, any sinner must repent. The first thing, give him the chance of that. You see, then only we can come up with the ideal society that we need. Right? Sometimes my mind, my thinking is a bit crazy. Okay? When it comes to thinking about, not crazy in the sense of gila lah, crazy in the sense of thinking about things. Right? How to carry out your khidmat masyarakat, community service. Right? For Muslim, I said, make a point that the offender, especially male, must attend subuh prayer for 40 mornings. Bring him back to society. Make him acceptable in the society by bringing him to the surah or to the mosque, supervised by the ketua kampung as well as the imam. The order is you have to give community service to the surah or to the masjid for 40 days. I remember in the olden days when people go to Mecca or Madinah for Hajj and Umrah, they said, I must at least have 40 days praying in Jama'ah. Why? Because he wants to transform himself spiritually. You can see our brothers in Tabligh, yeah, 40 days out. It is just for the transformation of the inside spiritually. Yeah? So 40 days without fail, praying subuh in the mosque perhaps will also help to transform this offender spiritually. And also he would, at the end of the day, feel accepted back by the society. Yeah?
Prof, I'm sorry.
That's my crazy idea lah. Uh, I was thinking that way. There must be some significance there about the 40 days. When people want to go to Mecca to pray Jamaah in Masjidil Haram and also Masjid Nabawi, for 40 days, when they come back, they hope to be spiritually enhanced and purified. Yeah. So, is there any time more for me?
Yeah, actually, we need to go to the next round.
Okay.
Let's
do the next round.
we can keep it for the next round, perhaps.
Don't
Thank
let
you
me
very
talk
much.
long.
Thank you very
I
much.
can have no full stop.
Okay, Prof. Thank you very much, Prof. Doctor, for your insightful, fruitful sharing just now. I'm so sorry to stop you at that point. Perhaps you can continue a bit on that after this. We have a very tight time, like, actually. Both our speakers for us to go for our second round. But again, we will try to maximize and make use of all the time that we have, around 15 minutes more to wrap up this program. And let us continue with our first speaker for the second round. Perhaps I can give around uh, 5 to 7 minutes, or perhaps 10 minutes. Okay lah, right? For our first speaker, Dr. Zainul. Perhaps Datuk, in this round, could you can you share your idea, or rather what is your envisage as far as how the Sharia court should look like in future, especially this post pandemic, when it comes to this accessibility to justice? You have shared with us a lot of scenario, a lot of problem and cases that you deal with during this pandemic. But what do you hope that can be improved, especially after this post pandemic? We are going to endemic. So what can we hope for the future? Perhaps 10 minutes, and also perhaps you can wrap up your answer as well, Dato'. Thank you.
Yes, thank you, Encik Mano. 5 to 10 minutes is a very daunting task to a lawyer because to say to do a compact speech. I have touched quite a number of things on civil matter, mild matter. I do agree with Prof. Mohamed in criminal matter, especially hard matter. Hearing through via technology, via online, I think it's not encouraged because there are a lot of maybe a lot of doubts will be created on the hearing itself, on the trial itself. I do agree with Prof with that. The only thing is that when we look at the Sharia court, especially on criminal matter, we will notice that 95% of criminal cases in the Sharia court end up with admission from the accused, OKT. Yeah? When accused admitted to the offences, then there would not be any trial to see whether he or she is guilty of the charge. Yeah? This is where the loopholes in the Sharia court, where the law will not be developed. Yeah? Civil court, we know a lot of charges has been contested. They file judicial review, they file appeal, they file review in the upper court, and end of the day, the court will say that, oh, this particular section is unconstitutional. This particular is should be interpreted this way and that way. Quite a lot of judgment we can refer to in criminal matter, but not in the Sharia court in criminal matter, because 95%, I would say that 95% are unrepresented, and most of them are ended with admission. So we don't have opportunity. The judges don't have the opportunity to write judgment on the interpretation of the law. And also I would say that if we were to increase the criminal jurisdiction of the Sharia court, maybe more cases will be heard and a trial will be conducted, because they will say that, oh, if I go to Sharia court, if I I plead guilty, I will pay fine for 1,000 ringgit. If I engage a lawyer, I may have to pay 5,000 ringgit to the lawyer, and I may not even end up with acquittal on the charges. So that are some of the predicaments for us lawyers to develop the law in the Sharia court, especially for the criminal matter. As I said earlier, I think whatever privileges and procedures enjoyed by the civil court should also be enjoyed by the Sharia court, especially in terms of independence, in terms of creativity, innovations, and because they have to follow a lot of instructions and guidelines, where end of the day they cannot dispense justice as per the Sharia law. Uh, as to the Pahang case that Prof said just now, she also end up with admitting on the charges. So there is no way for a lawyer to argue that the law is not is unconstitutional, the law is ultra virus on that or not, because she herself admitted to the charge and sentenced as per the Pahang law. The law has not been tested, as I said, because the interpretation of the law, the interpretation of the constitution does not belong to the Sharia court. It belongs to the federal court. So there are a lot of kena ikat tangan, a lot of ikat that has been faced by the Sharia court, that we want on one hand, we want the independence, we want the justice to be served. On the other hand, we don't allow the Sharia court to dispense justice freely as per the law, and there are a lot of things that have to be guided by to the Sharia court. I think during the pandemic, we are shifting to the endemic period. We have to live with the new norms. I think for the online hearing, for the civil matters, at least for submission, for affidavit cases, I think I would propose that we may have to go for online hearing. But for we cannot apply a blanket application to all cases, but some cases such as criminal cases, cases where trial are very extensive, we still have to go on with the physical trial. We have to modify a bit on the procedure. If we look at the civil court, we have Court Rules 2012. There are rules, but in the Sharia court, the procedure are in the forms of enactment. If we want to amend the procedure, the law has to be tabled in the Dewan Undangan Negeri. So the process are longer and tedious. And you know, when it comes to politicians, there's a lot of issues that will be raised in the Dewan Undangan Negeri, in the parliament, compared to the rules in the civil court. It is a mere rules. There are rules committee who can amend the procedure, the rules in the civil court, but not in the Sharia court, where the Sharia court, they have to table the rules in the Dewan Undangan Negeri or Parliament for federal territories. So it will delay the progress of the Sharia court in terms of the procedure, whether it is civil procedure or criminal procedure. So I think that we have to look at a lot of aspects in order to give fair and fairness to parties and accused or the prosecution, a lot of things has to be dealt with. We have to look at on the macro aspect as well as the micro aspect in order for us to say that Islam is a better way of life, and we have to give the fairness, the justice, the accessibility of justice in the Sharia court. For the time being, I think if the process is the procedure is what has been in existence, I think we have to do a lot of more work. Maybe academician has to contribute a lot on the improvement of the Sharia court from now on. Onwards, I'm glad if I know Prof. Mohammed is there in MMU. I think he can have a lot of his ideas. I would not say crazy ideas. It will the ideas can be translated into law. The ideas can be imposed and enforced to the Sharia court and the parties as well. Thank you very much.
Thank you very much, Datuk, for your sharing just now. I think that is a down really to earth problem and also solution that we need to cater for the time being. I think is something that need to be considered by all the parties as what you have said just now. So, Prof, we also have a very tight time for you. Perhaps 5 minutes. I don't think we have more than that. Prof, perhaps just a brief idea, or perhaps your sharing. How can we, in as an academic, as an institution, especially in MMU, perhaps would we can contribute to the betterment of this accessibility to justice, especially when we talk about the on the part of Sharia court, Prof.
Well, I can only say from my experience in Maldives for 3.5 years, from 2000 to 2003, end of 2003, and also in Brunei for about 10 years in all, about the involvement of higher educational institution in the implementation of certain laws. Okay, like in Brunei, when His Majesty the Sultan expressed his aspiration to have hudud law in 2012, I was then the dean of the Faculty of Sharia and Law at University Islam Sultan Syariah Ali. I was the one who couldn't sleep at night because I said, are we capable of handling these serious matters, right? So Sultan wants it already, but we are the only law school, and we have combined law and Sharia in Brunei. So I was the one who had been thinking day and night what to do. So I started to do my own study, and I bumped across a good research by a former Pakistani professor who had migrated to England to Warwick University. Her name is Professor Shahin Ali. He observed what happened in Pakistan when Pakistan introduced hudud law in 1979. When President Ali Bhutto introduced hudud law, it is enforced simultaneously. Judges are being appointed and elevated to the bench, and then they started to have the law enforced. There we can see a lot of hiccups and problems, whether they are ready or not. So whether the practical side of the law was really understood or not. Okay, so this professor, he found out that the failure that they had, the hiccup that they had in Pakistan was due to the uh, system of learning and teaching Sharia in that sense, right from the fiqh book. What we normally do traditionally is to emphasize on uh, knowledge and understanding. Okay. Whereas you look at the approach in the West, like in UK when you study law, they put four things, important thing in the learning. The knowledge and understanding is one thing, number one, of the law. Secondly is the intellectual skill, how you develop your intellectual skill to really know what is actually the issue in the case, right? and then application skill to know to apply the law that you have learned into the issue, right, into the facts, and then how you transmit. We have transferable skill. How you write your judgment, how you argue, put on your argument in the case and all. Those are the training that we have, right? But sad to say, since about more than 10 years ago, we have adopted the Bloom taxonomy, which is make it more complicated and then time consuming, and then we become exhausted. Right? All this while, when we learn law from the British style, emphasis is on form. And then when it comes to Sharia teaching, it's more rote learning, hafalan. And then I have students, postgraduate students in my faculty in Brunei, who graduated from Mesir, from Egypt, from Kuwait and all. When they attended my Kanun class, Kanun International class, there's so many things they cannot solve. See? So many things they cannot go into it to really understand what's happening. So when I said how to prove theft, they only come up with 2 adil witnesses. So that is very basic, very, very basic. You know, this graduate from overseas, when I ask that question, how can they help in developing the system there? See? So that's why I introduced the subject to read the law from cases. Right? Learn from the failure of some cases in Pakistan and see where they go wrong. What to do first, how to identify the issues, and then what should the law to be applied, what law should be applied, what principles should be applied, rather than picking up the fake book, that's it. Right? We have seen a lot of thousands of conviction on hudud in Pakistan, which had been quashed by the appellate court, the Federal Sharia Court, and most of the cases were substituted to the discretionary, punishment. Right? So we take pains to study all those things to come out how to read the law, even how to read the penal code, the Sharia penal code. We need to digest every element required to be proved. Right? Like Sariqah just now, like theft. Every single thing, there are 4 things, as said by Abdul Qadir Audah, there are 4 things in the definition of Sariqah. Prove that. Don't simply read and then try to use other material to prove the case. No, you have to go by the statute itself. What it means. And then you go to the kitab fiqh or other Quranic ayat or hadith to support your argument. Right? Sometimes when we give problem, they can't even identify what issue. Right? That's the problem. See, all my questions in my class are all problem questions. Whether it is zina, theft, or robbery, or whatever, when I taught there, I want to test whether they have the enough intellectual skill to go about. I'm not following my own style. I read the work of Professor Syed Ali. He said many graduates in Pakistan also come from the faculty of Islamic Studies. Yeah? They have Sharia degree from Islamic Studies. The teaching and learning is different, but since they have the degree, they become judges. They become lawyers, right? They don't know the intricacies of how to prove, how to disprove, right? How to go into criminal matters, right? This is the problem that we have there, the hiccups that we have there, right? So those who come from the Sharia wal Qanun, they may understand more than those coming out from the Islamic studies, right? But they have same nomenclature on the degree. Behind them, who knows? Nobody knows, right? Whether they are really capable or not capable in running the show. I still remember when I joined UAE as a student, right? In early 80s, first batch of UAE as a student UAE in early 80s. Our almarhum Sheikh Mohsin, the person who taught me, the teacher who taught me Quran, he said, Brother Muhaimin, masa saya balik daripada Mesir ke mana ke, saya dilantik sebagai hakim Mahkamah Syariah. Terkejut saya. Saya hafal Quran. Mana he didn't learn the mechanic of Syariah practice. Just a person who memorized Quran. He had to surrender, he had to decline. Very recently, he declined. But some people, they may have no job. Okay, no problem. Simple thing. Fiqh book is there. So this is the thing, the amanah must be there, see.
Okay, Prof.
I've seen, yeah.
Okay,
I've heard also,
we actually,
one more point. I heard also
okay.
a person who is having a degree on Arabic literature, not in Malaysia, being appointed as a judge in Syariah court. So that's why I like that verse, Whenever I taught Syariah in Brunei, I read that verse first, right? About the amanah and the Syariah. Ini apa tu keadilan, the justice. Okay, thank you very much, Mr. Mahno.
Okay, thank you very much, Prof. Prof. Doctor. Thank you very much. We are actually at the end of our webinar today already, Prof. Doctor. I personally actually would like to extend this, but yeah, what to do, because this is we are just we are the invited speakers as well as the moderators. So basically, perhaps we can continue this in other avenue, perhaps in future, Prof. Doctor, and also Dr. Zainulijah. On behalf of the speaker again, yeah. On behalf of the organizer again, I would like to apologize for all the hiccup or all the shortcomings throughout these webinars. And before I close this, I would like to thank as well again to all the speakers, invited speakers, Dr. Zainulijah Abu Bakar, as well Prof. Dr. Mohamed, the Center for Sharia Laws, the Faculty of Law, Multimedia University, the Industrial Collaboration and Engagement Center, ICEC, and the Research Industrial Collaboration and Engagement Division, RISE, MMU, the Strategic Marketing, Admission and Recruitment Division, SMART, MMU, MMU Studio, and the technical support team for making this webinar conducted smoothly, and not to be forgotten, all the audience that had been spending their time listening to us today. With that, until we meet in the future, take care, everyone. Stay safe, and thank you very much for all your times today. I am, as the moderator, again apologize for all the shortcoming, and until we meet again in the future. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh, and a very good day.
Assalamualaikum.
Multimedia University, because MMU is you, leading the digital future. Visit mmu.edu.my.